ask at that time. The Chair calls Craig Eiland. Craig, I've got you here on behalf of the Texas Trial Lawyers Association, and yourself registered against the bill. Is that correct?
That's right,
All right.
Mr. Chairman. This is the third session that I know of that this bill has been brought, and we still don't have any examples of an abuse by Texans or Texas entities in this regard. This is unilateral disarmament of Texas citizens and Texas counties and cities and school districts by taking away this right and remedy. And you're taking away this remedy even for defective products. I don't know how or why we would ever take away any remedy for a defective product. If an ordinance is passed in Houston under the bill, the way it's written, it could impact whether or not Odessa has rights. Because if a ordinance is passed in Houston, it could impact Odessa. Down at the bottom it says if a state agency has passed a regulation that has an enforcement mechanism for the conduct, it doesn't say that the remedy that agency has for it has to be adequate. It just says that the enforcement mechanism already exists to address the conduct. And lastly, I think one reason why we don't see an abuse of this in this state is because public entities that are going to pursue a claim like this on behalf of their citizens or their community, they would most likely have to go get a contingency fee contract in order to do so. And Texas has changed the law on that in 2254, where they would have to have a public meeting, a public notice in order to hire contingency fee lawyers, and then the Attorney General has to approve that contract. So we have steps and in place to prevent abuse of anything, and we have.
All right. Chair calls Jack Walker. Jack, you here on behalf of yourself and the Texas Trial Lawyers Association registered against the bill.
That's correct.
All right.
Thank you, Mr. Chairman. My name is Jack Walker. I'm the president of the Texas Trial Lawyers Association. I'm here to testify in opposition to House Bill 3964. As Mr. Eiland said, this is the third time we've been back talking about the doomsday flood or the potential doomsday flood of public nuisance lawsuits that could happen, and they haven't happened, and still haven't happened. The 10 lawsuits that Representative Massoud would reference are all lawsuits that happens outside of Texas. We haven't had it. The reality is public nuisance claims are brought in cases of serious, widespread harm to the public, and precisely what the legal doctrine was designed to address. The only examples you'll find in Texas that we can look to are the opioid litigation. $3 billion brought back to the state of Texas. You may hear arguments that the state of Texas didn't use nuisance as their cause of action. My law firm filed the first nuisance cause of action in the state of Texas for Hopkins County. I represented about 34 counties in the state of Texas. We used nuisance as our primary cause of action, and every one of those cases brought $3 billion back to the state of Texas. This is a unique committee because everybody on this committee is a lawyer. Everybody on this committee spent 3 years studying to uphold the rule of law. A bill like this ought to set off alarm bells in everybody's head because it is brought to eviscerate a common law cause of action. Nuisance is unique in that it is a plea in equity, and it is both a tort and a remedy. And the reason it is so powerful, because when you have a large public harm, it allows the governmental entity to come in and abate that harm. And so when you dismantle the foundational of these remedies, you are threatening the framework of our civil justice system. And I'm happy to answer any questions.